4 was crafted in the memory of the late Congressman John Lewis, and it's about voting rights that he fought for and appropriately honored for. The unfortunate reality is that this hearing is another attack on the Supreme Court, and this bill is yet another attempt at federal takeover of state and local elections. It wrestles control of elections away from the state and into the hands of the Biden-Harris Department of Justice and partisan lawyers backed by dark money groups. Before discussing the matter at hand, I want to say that we're grateful to have a number of extraordinary busy state officials and former state and federal officials we heard from who were eager to testify against this bill. This was even more impressive for this hearing, given that the second panel was unsettled until just last Friday. We truly appreciate all their efforts and their outreach. Revising and reviewing this bill, I can see why so many experts were willing to rearrange their schedules. This bill is a disaster. It penalizes states for voter ID laws, which an overwhelming majority of Americans support. Even Democrats claimed to support ID laws earlier this year. It fundamentally changes who is responsible for elections in America, replacing states with the federal government. Why change what has worked for 240 years, in which the Constitution is very clear that the manner of holding elections is up to state legislatures? This is the fourth hearing regarding voting rights in the United States Senate this Congress. We had a subcommittee hearing 2 weeks ago on the same topic, but this did not seem like a process designed to learn more from the experts and state officials responsible for running elections. It seemed rushed so that we could say that we had another hearing. Look at this bill's history. This bill has been proposed in various names and with slightly different provisions all the way back to 2015. It was proposed in direct response to the Supreme Court's 2013 decision, Shelby County. That case recognized that the landscape in America looked very different in 2013 than in 1965, when the Voting Rights Act was passed. And the Supreme Court concluded that Congress couldn't keep requiring states to pre-clear with the federal government election law changes based on data going back to 1965. Fast forward then 8 years, and the Supreme Court again issued a decision, this time the Brnovich versus Democratic National Committee. This case, the Supreme Court set forth a list of substantive guideposts to determine whether, considering the totality of the circumstances, changes to voting rules are lawful under Section 2 of the Voting Rights Act. Unsurprisingly, Democrats immediately set about revising this bill to overrule the Supreme Court's common sense decision. The latest version doesn't just revive the pre-clearance procedures in place before Shelby County, it massively expands pre-clearance. Democrats also want to erase the very reasonable factors that the court outlined in Brnovich to guide lower courts as they look at the totality of circumstances for changes to voting laws. H.R. 4 replaces those Supreme Court guideposts with a list of undefined and far more vague factors, such as difficulty complying with voting requirements. These factors don't provide any legal clarity. What they do provide is enormous opportunity for mischief by Democrat lawyers. If the activist lawyers, backed by an unending flow of dark money, can find a few violations under this amorphous standard, then a state is subject to preclearance. That gives DOJ control over jurisdiction for a period of 10 years. As written, H.R. 4 would also give the Department of Justice the power to retroactively look back at a jurisdiction to determine whether, in the past 25 years, the jurisdiction had sufficient number of violations to warrant imposing pre-clearance right now. Pre-clearance worked wonders in 1965. It was needed to ensure the vote for minority communities that were denied the right to vote by poll taxes and literacy tests. Those laws have thankfully been erased from the books. We have recently had record turnout for minority voters. So why are we expanding pre-clearance in 2021? Do we really want the Department of Justice exerting this level of control over our states? This is the same DOJ that only yesterday distributed a memorandum vaguely threatening to use the FBI to investigate parents protesting school teaching critical race theory in the classroom if those protests, quote unquote, intimidate school board members. Do we really want to give partisan activists who claim that paying for postage stamps to mail in a ballot is a poll tax the ability to subject a state to burdensome federal regulations and oversight? Do we really want to give Democratic operatives unfettered power to bring states under pre-clearance with lawsuits resting on vague notions of quote-unquote violations? To that end, I hope to hear from Attorney General Rokita, who was previously Indiana's Secretary of State, why it's so important for states to manage their own elections, and while federalized election laws are bad for election integrity, and most importantly, voter participation. I hope to hear from the Honorable Ken Cucciarelli, who was the Attorney General of the Commonwealth of Virginia when pre-clearance was outlawed, the impact of imposing pre-clearance procedures would have moving forward. Now, before I wrap up, I'd like to take a moment to introduce, for the record, two written statements that I believe warrant recognition. Lieutenant Governor Mark Robinson's described the flaws in H.R. 4 and noted that, quote, this legislation is nothing more than an attempt to ensure that one party control the machinery of our government in perpetuity by mandating an unconstitutional federal takeover elections in our country, end of quote. I also appreciate that a legal advisor to the bipartisan Carter-Baker Commission, Thorne Hearn, noted that H.R. 4 is the, quote, the antithesis of the Carter-Baker Commission's bipartisan recommendations for election reform, end of quote. We would be wise to heed their concerns with regard to H.R. 4s. So sadly, my Democrat friends seem to disagree. They're pushing H.R. 4 to take away the ability of states to establish their own voting rules. We should all agree that participating in American democracy at the ballot box is a fundamental right. It's a right that we should want to protect and not outsource to political operatives in DOJ and activist outside groups. Thank you.